this time, I will call the June 15th, 2026 meeting of the East Hempfield Township Zoning Hearing Board to order. Members of the board who are present this evening are Mr. Kyle, Mr. Caldis, and myself, Mark Hanson, Chairman of the board. Also, for the record, we have Mr. Manns, our zoning officer to the township, and our legal counsel, Attorney Jason Hess, as well. We also have a court reporter with us. Scheduled for this evening is one new case and any old business that may come before us this evening. The board will hear each case in an informal manner without strict compliance with the rules and procedures used in a court trial. We ask each applicant and any individual interested in a case to step in front of our table and explain the circumstances involved in their application. Applicants may present their case themselves through their attorneys or any other representatives. My fellow board members and I, as well as our solicitor, may ask the applicant questions from time to time during the applicant's presentation or at its conclusion. All persons having an interest in the application will be given the opportunity to ask questions of the applicant, offer evidence of their own, and inform the board of their position on the matter. In the interest of prompt and orderly disposition of each case, however, we ask that interested people refrain from speaking until the application's presentation has been completed and the board has had an opportunity to question the applicant. At the beginning of each case, people who are interested in the case should decide whether they desire to be a party to it. By given the status of a party, that person would be entitled to receive notice of the decision in the case and be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions or present evidence, but will not receive notice of the decision or will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be a party, we ask that you sign an entry of appearance form at the appropriate time. Although each party will receive a written copy of the decision, the mechanics in typing and signing the decision will take approximately 4 weeks. We ask that each person who asks a question or makes a statement first state his or name and address to our court reporter. Lastly, in the interest of time, I'll administer the oath or affirmation to all applicants and to everyone and anyone who anticipates making any statement with respect to any of the hearing this evening. At this time, will you all please rise? Under penalties of perjury, you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth. If so, please say, I do. Please remain standing. We'll salute the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Couple of quick notes here. Just remind everybody that this meeting is on Zoom. So if you do ask any questions or have any comments, I ask that you please use one of the microphones in the room. Jeremy, have the cases this evening been posted and advertised in accordance with the Sunshine Law and the ordinance?
They have.
Gentlemen, you have received a copy of the May 11th, 2026 board minutes as presented by our secretary. If there's no deletions, additions, or correction, I ask for a motion to approve the board minutes as submitted.
So moved.
Do I have a second?
I'll second it.
Motion by Mr. Kyle, second by Mr. Caldis to approve the minutes. Mr. Caldis?
In favor.
Mr. Kyle?
In favor.
And I will also vote in favor. Minutes pass are approved 3-0. Jeremy, any old business?
No.
Will you call the first case, please?
Case number 2499, C&H Materials 929 Quarry Road, seeking a 400-foot setback variance for a quarry use and the time and requirements to act on the zoning hearing board's decision.
Anybody here for G&H? G&H, I'm sorry.
Mr. Chairman, do we, gonna ask if there's any
Yeah,
additional
I'll
parties?
get
Okay.
there in a second. All right, before we get started, is there anybody in the audience that wants to be a party to the case?
Representing Matthew and Vanessa Elliott, who are adjacent landowners. They have approximately 26 acres adjacent to this property, the agricultural zoning district along Route 76.
Are they here this evening?
Mr. Elliott is the
Mr. Elliott, will you fill out a form, please?
Got 'em on the table there.
Anybody else? Again, just remind everybody, even though you are not a part of the case, you can still ask questions and make statements. Would you do me a favor, sir? Would you hand that to our attorney when you're done?
All right, Mr. Chairman, the additional party is Matthew T. Elliott. The address is 1999 Turnpike Road, Elizabethtown, PA 17022. And the interest in this matter is
If I may, Mr. Hess, it's an adjacent property. It's not yet built upon the current improvements, so it does not have a street address. It has the Lancaster Road property immediately adjacent to the property. As you look at the property from Route 72, it's on the left. It's the first property in the agricultural zone.
okay. You said from 72, it's immediate to the left. Okay.
Shares about a 1/2 mile boundary with the property.
Okay.
I'm sorry, your name again.
Kurt Williams.
Mr. Williams, any objection?
The council's representing is the property directly to the north and west,
That is correct.
then no objection.
So accepted as a party to the case. All right, Mr. Williams, go ahead with your case, please.
Thank you, may it please the board. Kurt Williams from Salzman Hughes on behalf of CH&M Materials. With me tonight is Rick Caranfa from Akins Engineering, project manager, and Rob Bowman, the principal of CHNN. We're here to present our variance application for the site at 929 Quarry Road, just east of Route 72 on the eastern edge of East Hempfield Township. Board may remember we were here in April requesting similar variance, 100-foot variance down from 500 feet, which is in the ordinance. And I'd like to incorporate the record from that case, which was 2496. I think that could save some time this evening.
The only problem with that, Mr. Williams, we have new parties to the case. We can incorporate the record, I think, but I don't. We would need to bring them up to speed on testimony.
Yeah,
Okay,
I mean,
well-
I think based on the fact that there's a party here that was not present for the first one, and they have the right to hear all the testimony that's necessary for the application, so.
Not a problem.
Okay.
Then I'm going to ask Rick Caranfa to come to the microphone. And he's already been sworn. Would you like me to review his qualifications? I guess, are there any objections to his qualifications?
No, we won't have any objections because we accept him as a witness.
There's a new party, so I think they should. have the
Go
right
ahead
to hear the-
briefly, please.
Yeah, but I don't want to make this thing more difficult. If the gentleman was qualified to testify in the prior proceeding, we will not lodge an objection.
Thank you.
Rick, can you state your name, please?
Rick Caranfa, Caran, F as in Frank, A. I'm with Akins Engineering, AKENS.
Did you assist with the preparation of the variance application before the board tonight?
Yes,
And I have already distributed a copy of the application. And is that a copy of the application that you helped prepare?
yes,
That application package that I handed out contains certain maps and plans. Should we mark that A1 for tonight?
You want the whole app? Okay.
And I gave a copy of that to council. And Rick, your role is still project manager?
yes,
And is this the same parcel that was discussed during case number 2496?
yes, there's two parcels.
Two parcels, correct. What's different about this application versus the prior application the board heard in April?
The setback is coming from the township line and which is also the same as the stream.
So the municipal boundary on the eastern edge of the property is used to hold the 100-foot setback as opposed to a property line that is inside Manheim Township.
Correct.
Okay. So is what's being shown on the screen now, is this a site plan that you prepared that was part of the application?
Yes,
And
While we have that up, can I interrupt you for 1 second? Mr. Elliott, your property is the one directly to the north and west there, correct?
oh, yeah, but he's looking.
Yeah, where it says
So,
agricultural
okay.
zone. Thank you.
Rick, using the laser pointer, can you point to the municipal boundary between East Hempfield and Manheim Township?
I'm gonna hit both, for their benefit, I'm gonna hit both screens, but
Do that one first, please.
okay. Sure. So that's the township line and the creek between Manheim Township and East Hempfield Township.
So the creek is the municipal boundary, correct?
Yes,
And portion of the 929 Quarry Road site that we're concerned about is completely within, the portion that we're concerned about is within East Hempfield Township, correct?
yes.
And can you point out how you're holding or proposing a 100-foot setback from the municipal boundary into the 929 Quarry Road parcel?
Yes, so it's 100 feet from the municipal boundary and the stream. And that's what I'm pointing to on the screen now. Do it both sides. So that's the 100-foot setback from the stream and the municipal boundary.
And if you could then trace around the rest of the property where you're continuing to hold the 100 feet setback, proposed 100-foot setback from other property lines, please.
Yeah, so that's the setback line is a kind of a purple blue. And this is a 100-foot setback along the property line. This would be the 100-foot setback off of the right of way of Route 72. And then these are setbacks off of property lines. And then again, we run up along the creek, and I'll repeat that. So this is this 100-foot setback along the property line, the 100-foot setback along 72, and then the 100-foot setbacks along other property lines, and then again the street.
And when we're talking about the stream, we are talking about the Little Conestoga Creek, correct?
Yes.
So what specifically is the variance request to the board tonight?
So the ordinance has a 500-foot setback from the property line, and we're asking for a 100-foot setback instead of the 500-foot.
And what kind of operations are allowed in the mineral extraction zone within that would be allowed in outside of the setback?
Outside of the setback, I don't know if there's anything with
No,
mineral
what
extraction.
Not within the setback, but
Okay.
within the blue area that you've outlined.
Yeah, so within the setback area, you would have mineral extraction, including all of your processing, stockpile storage, and all operations that would be associated with the mineral extraction would be within that setback.
And if the owner was required to hold a 500-foot setback as required by the ordinance, what would be the effect of that?
So the current drawing that you're looking at with the purple line, that's about just a little under 30 acres that would provide for the mineral extraction activity. If you did the 500-foot setback, you'd end up with just a hair over 2 acres.
And can a mine feasibly exist on a little over 2 acres?
Not a large non-coal surface mine.
So let's run through the 5 variance criteria that are statutory and within the zoning ordinance of East Hempfield Township. I'm just going to paraphrase if I can. The first criteria is there are unique physical circumstances or conditions. Can you describe what those are on the site?
Yeah, well, I mean, the first and foremost is the setback that comes along with the ordinance that would allow them to mine the site. I mean, the unique circumstances is it's zoned properly for mineral extraction, and it does have a limestone, which is a typical quarried stone in this area. There's a quarry right across the street, so we know there's a market. We know the material is there. And we know it's within, it's accessible, so you can't have too much overburden over top of it to be able to access that mineral. And the unique part of it is it's a mineral that's got to be mined where it was formed. There's no other choice about that.
Hey, you familiar with the quarry across the street?
Yes,
Who operates that quarry?
NC Supply.
And you're generally familiar with the history of that quarry? Was that mine developed under a regime with a 500-foot setback?
No.
Do you know what was in effect then?
It was prior to zoning ordinances. There's sections of the existing quarry high wall that are 8 feet from the Route 72 shoulder.
Now, if you apply a 500-foot setback or even the 100-foot setback, do you arrive at some irregular shapes within the mineable area?
Yes.
On the site?
Yes, it's not a square property.
The second variance criteria, because of such physical circumstances or condition, there's no possibility of the property being developed in strict conformity with the provisions of the chapter.
Yes, so it's zoned, mineral extraction, and I don't think you can, mine, you can't use that use, with a 500-foot setback.
Does it make sense to use this site for mineral extraction versus other uses that could possibly be done here?
So the uniqueness with the mineral extraction is, one, there's no other, mineral extraction zoned parcel that isn't being mined. So it's kind of the last parcel that you have, under your zoning ordinances that's zoned for that isn't already being mined.
What is the mineral that's mineable here?
It's a limestone.
Specific type?
Buffalo Springs is the target.
Such unnecessary hardship has not been created by the applicant.
No, I mean, it's where the mineral is.
That's where it is.
It's where it was there, millions of years, to form.
And a 500-foot setback prevents it from being efficiently mined
Correct.
on the site.
Correct.
The variance, if authorized, will not alter the essential character of the zone or the neighborhood.
Clearly not, because we have existing quarries right across the street.
The variance, if authorized, will represent the minimum variance that will afford relief and the least modification possible of the regulation in issue.
Yes, the 100-foot setback off the stream is the DEP setback, and the same for the roadway. It's a 100-foot setback from the right of way. So the 100-foot is very similar to what the DEP setbacks are.
And in the history of East Hempfield Township's zoning ordinance, specifically regarding mining, was there a time when a 100-foot setback was the rule for mining?
Not really, no. I mean, it's, so you have, varying setbacks from the streams. So you have the 100-foot from the stream and roads, and there are setbacks from occupied dwellings, which is 300 feet. And all of that you'd still have to, submit an application to the DEP and meet all of those existing, regulations, under the Chapter 77, Pennsylvania Code. So you would still have to meet all of that, all those setbacks.
I think last time we discussed that prior to 2014, East Hempfield had a 100-foot setback for mineral extraction. Do you recall that conversation?
Yes, yeah.
So pre-2014, there was a 100-foot setback for mining in East Hempfield.
Yes, I believe that's
After
correct.
2014, that changed to 500 feet.
Yes, I believe that's correct.
I think before that, it was a sliding scale. There was a 100-foot setback, a 200-foot setback, 3, 4, and 5, depending on the uses of the property, if I'm correct on that, right, Nate?
That's correct. There was a table that had varying setbacks.
I think we discussed that the setback that would have applied to this quarry pre-2014 was 100 feet, it was 100 feet.
Generally, yes.
And finally, in granting a variance, the zoning hearing board may attach reasonable conditions as it deems necessary. And does the applicant acknowledge that?
Yeah.
Yes, okay. All right, that's all the questions I have for Mr. Cranfa.
Gentlemen, any questions?
You guys might get questions
Yep,
from.
sorry.
Not at this time.
I do have one question for you. This area is made up of 2 properties. What you're asking for tonight, is any of that still on the second property?
Correct, yes.
So would you still be willing to accept as a condition that the properties have to be joined?
Yes.
I can't answer that, but I believe you can check with
Mr. Bowman can answer that, but
Okay,
I believe the answer to that is yes.
okay. Thank you. Anybody in the audience have a question for this witness? Go ahead. You can use one of those, or you can remove, those are removable.
Mr. Hanfield, I believe you said that you prepared this application, assisted in its preparation?
Yes.
The April hearing that was referred to, was there a disposition of that matter or was it withdrawn or continued?
I believe that was denied.
That was denied. So the answer to the question under general information A, has this property been involved in a previous zoning hearing? No, would actually be incorrect.
Yes, I would believe so.
All right. Directing your attention, you went through several hardship criteria with Mr. Williams. With respect to the first hardship, you talked about unique physical characteristics of the property, and I believe you referenced the fact that the request was a result of the 500-foot setback that created the unique physical characteristics of the property, correct?
Including the mineral extraction zone itself.
Okay, that's correct. So the zoning ordinance itself creates that unique physical characteristic because of the fact that it has a large setback.
Well, that and it has the mineral to be mined. So you would need that as well.
So you would have to have mineral underneath, you're saying, in order to make it a viable
Correct.
quarry or mine.
Yes.
But the other factor is the fact that it is a substantial setback. Is that correct?
There is a substantial setback, yeah.
Do you have the application in front of you?
I have portions of it. I don't know if I have the whole thing, but
Well, do you have section 2 specifically after Mr. Bowman's signature says section 2 variance request? Do you have that section?
I do. Yeah.
I'm going to direct your attention to 6A, and that is the criterion that deals with unique physical circumstances. You would agree?
Yes.
I'm going to direct your attention to the last 3 lines of that, starting with "and not the circumstances or conditions generally created by the provisions of the ordinance in the neighborhood or zone in which the property is located." You would agree that that particular criteria, the fact that the zoning ordinance imposes a condition, doesn't make this property unique, does it?
Not necessarily, but the mineral does. Yeah.
The mineral makes it unique.
Yes.
It simply makes it present, does it not? If it didn't have, we wouldn't be here tonight.
Not every property can be mined.
I understand, not every property can, but that doesn't mean that
That is a
every,
uniqueness.
but does that mean that every property that has a mineral can be mined?
No, not necessarily. There's
Exactly.
many things that go along with that.
All right. Also directing your attention to the identity of the applicant. Do you know who owns this property currently?
Yes.
Who is that?
I believe it's C&A Development.
Okay. Is that entity affiliated with the applicant here, CN&H Materials?
I do not believe so, but I'm not 100% sure.
Okay. Mr. Bowman would be able to answer that question, I assume. Is that correct?
I would believe that.
Okay. But as far as you know, there is no connection between the two.
Not that I'm aware of.
And you also are aware, I believe, because I believe the application references that this is an equitable interest in the property. Is that correct?
Yes.
Does that mean there's an agreement of sale to potentially buy the property?
Yes.
And that is, do you know the contents of that in terms of the contingency on getting an approval for the setback?
I don't know all the details of the agreement.
Do you know that particular detail?
No, I don't.
You don't? Okay. So as far as you know, if you don't get the variance, then the applicant would have the ability to walk away. Is that correct?
I don't know.
Okay. Now, you've also reviewed the ordinance, I'm sure, with respect to the regulations in it concerning the mining or the quarrying, whatever you want to call it. You did?
Yes.
Okay. So directing your attention to subsection, I believe it is 20, would identify that no structure or parking area may be located within 100 feet of the property line. Is that correct?
I believe so.
All right, so you're asking here this evening for the setback to be reduced to the same as putting a building or a structure or a parking area anywhere on this lot outside of that 100-foot setback?
We're asking for a 100-foot setback.
Okay, and that, so that would allow all of the mining or quarrying operations to take place within that building envelope, correct?
That's correct.
All right. And will there be blasting with this mining?
Most likely, yes.
Okay, and so your suggestion in your testimony is that this would not have an impact on the district or any neighboring properties? I believe you testified to that, is that correct?
Did.
So that the reduction of a 400-foot in the distance of the setback would not have an adverse impact on my client's property, which is immediately adjacent and in the agricultural zone?
I believe that there are setbacks that DEP has in place for blasting, and that's what we should be using.
I wasn't asking that, Mr. Karenfeld. I asked whether your testimony is that it wouldn't have any adverse impact if it were reduced from 500 to 100 feet.
I don't believe so, no.
Okay. The property, what's the current use of the property?
It's a agricultural field.
Is there a residence on it?
There's a house and a maintenance and a farm vehicle maintenance.
So the property is an active agricultural use, you would agree?
Yes,
And that use is a permitted use as a matter of right in this particular zoning district, correct?
I'm not 100% sure about that, but I believe it probably would be.
Okay.
I'm not sure.
Contractor storage would be permitted here as well?
Yes, it would be.
Okay. So what you're saying basically is you don't think this property is large enough to mine with the current conditions imposed by the zoning ordinance. Is that accurate?
That is accurate.
Okay. I have no further questions. Thank you.
Anybody else in the audience have a question? Township have any questions? Jason,
No.
you can proceed with your next witness.
Mr. Rob Bowman?
You can take that out if you want to just hold it.
Thank you.
Mr. Bowman, you've already been sworn. Could you introduce yourself to the board?
Yes, Rob Bowman, principal of CH&M Materials.
Let's get one thing out of the way first. The applicant here tonight is different from the owner of the land.
That's correct.
Is there any affiliation between you and the current title owner of the land?
There is not.
And you have the property under contract to purchase it.
We do.
Makes you an equitable owner.
It does.
Just give us your background and why your company is interested in this site for a quarry.
So we have been in the heavy construction, road infrastructure and utility work for more than 30 years. And we purchase a large amount of construction aggregate from providers across the state. We have an interest in developing this as a source for construction aggregates for our operations and for sale to third parties.
Primarily would serve local construction needs because rock really doesn't travel well, does it?
That's correct. There's a large part of the cost of construction materials, including aggregates, is transportation costs. So there's a limit for how far you can economically ship and obtain construction materials. So this would serve the local market, East Hempfield, and the surrounding municipalities and the northwestern part of Lancaster County.
Rick testified earlier that the properties actually consist of two parcels. Do you remember that testimony?
I do.
And as part of any approval of the variance requested tonight, and the furtherance development of the mine, would the applicant agree to a lot consolidation if that was required by the township?
Yes, we would agree to consolidate the two separate, separately identified parcels into one parcel.
Also known as a reverse subdivision.
Another way to say it, yes.
Since the plan is to develop a quarry on the site, that requires permitting from the Department of Environmental Protection, correct?
Correct.
And has the applicant asked for, in addition to the 100-foot variance, has the applicant asked for an extension of time under section 270 9.1D 13E?
We have.
And have you asked for that because of the time necessary to get a quarry permit through the DEP?
Yes, we have. We've asked for an extension to best reflect our, what we would anticipate obtaining the appropriate state permits for operations.
If I may, we submitted this application with a 12-month extension as we did the last time, not wanting to appear greedy, but the board last time seemed amenable to a 24-month time extension. I'm going to ask Mr. Bowman, if the board was amenable to a 24-month extension, would you request that?
We would.
Anything else you'd like to add?
Not that I can think of.
I'll tender the witness.
At this point, would you like to amend your application to request the 24-month time extension?
We would.
Gentlemen, you have a request by the applicant to amend their application to ask for a requested 24-month extension to the time application. Do I have a motion?
So moved.
Do I have a second?
Second.
Motion on a second to amend the applicant's application. How do you vote, Mr. Caldas?
In favor.
Mr. Kyle?
In favor.
I will also vote in favor. Your application has been amended.
Thank you. I'll tender the witness.
Gentlemen, any questions for Mr. Bowman? I have some, but I'm going to come back to myself later. Township have questions?
No.
Jason?
No.
Anybody in the audience?
I do, if I may.
Go ahead.
Thank you very much. Mr. Bowman, you confirmed that your company is not affiliated with the owner, is that correct?
Yes, we are not affiliated with you.
Right, and you have an agreement of sale with the owner to purchase this property. I'm sure there are contingencies in that agreement. Is that fair to say?
There are.
And is one of the contingencies you're successfully getting a variance for this property?
There's a number of contingencies. I don't know if this is specifically one of them.
You're not familiar with the agreement?
I am. I don't have it here for reference.
I see, but you are able to, are you able to walk away from this agreement if you do not get the variance? Well, the relevance, if I may, Mr. Chairman, is the fact that one of the criteria for a variance is that the applicant did not create the hardship. And so in this particular situation, I believe that Mr. Bowman's answer would confirm that he has the ability to walk away from this agreement if he does not get the requested zoning approval, which that clearly makes a situation where an applicant would not be suffering a hardship by virtue of the denial of this. He has merely an equitable interest. If he were the owner now, he might be able to make an argument that there was a hardship. But in the absence of that, he clearly fails on one of the 5 necessary criteria for a variance. So I believe the question is relevant.
Mr. Chairman, if I may, I believe that, especially given relaxed rules of evidence for zoning hearing boards, that this would be relevant in terms of what the board has to consider.
I'm going to overrule your objection because number one, this board, the majority of this board in many, many years has always not liked the use of the ordinance to or the property, as a, problem. So I'm going to allow the question.
So, Mr. Bowman, do you have the right to walk away if you don't get the variance?
We have the right to not complete the transaction for a variety of reasons. So, I mean, we would have the right to not close on the property. But that's, I mean, you know, whether that happens or not is yet to be determined.
So in other words, you might buy this property even if you don't get the variance.
I'm not saying that either. We're here to get the variance. We've made application for the variance this evening, and we haven't made any decisions regarding what we'll do with the property should we not obtain the variance.
That's right, but you've also alleged in your application that you have a hardship if the variance is not granted. In reality, the only hardship is that if you don't get that variance and one believes that you can't otherwise mine this property, that you can't mine the property, correct?
Could you ask your question again?
Yes. If in fact the variance is denied, you have alleged that there would be a hardship. But if you don't purchase the property, there is no hardship, correct?
Well, the property is currently zoned for mineral extraction. The ordinance, the setback that's currently required precludes that from happening.
Okay. All right. So do you or do you not know if you have the ability to not complete the transaction if you don't get this variance? It's a simple yes or no question. Do you know?
I think I've already answered that.
Do you know?
I don't have a copy of the agreement
Okay.
here. I don't know the terms of the agreement specifically.
All right. Do you operate other quarries? Does CNNH operate other quarries?
We don't currently operate another one.
Okay. All right. And so you're actively looking throughout the area for opportunities like this?
We are, yeah. We're,
Oh, hold on.
Okay, well, Mr. Bowman testified that one of the essential things here is the fact that I believe it might have been Mr. Williams' words, rock doesn't travel well. And so if they have operated other quarries, I think it's fair to ask where they've operated other quarries and areas where they've looked for other quarries, because that's part of their argument here.
But let me ask you that question. The question is, what relevance does that have to East Hempfield Township? Because
Okay.
we can't take into account what any other township does.
I'll withdraw the question.
Thank you.
I'll withdraw the question. I have no further questions, Mr. Bowman. Thank you.
Jason, do you have any follow-up questions?
No, I don't.
Anybody else in the audience? Gentlemen? Mr. Williams, continue. You need to continue.
Have no more witnesses. No more witnesses, just a little bit of argument.
If you want to make a closing statement, please do.
And Mr. Chairman, it might be best to allow both of them to make closing statements after the entire case, because I'm guessing you would have some
I
testimony
do have
as
some
well.
testimony.
Well, go ahead with
Can
your
I bring
testimony.
Mr. Elliott right up here and have him use one of the microphones? Mr. Elliott?
Please.
Mr. Elliott, for the record, would you state your full name and residence address, please?
Matthew Elliott, 1999 Turnpike Road, Elizabethtown.
And Mr. Elliott, are you the owner of property located in East Hempfield Township that is adjacent to the subject property here tonight?
Yes, my wife and I.
When did you acquire that property?
We purchased the property at auction on October 9th and closed roughly 45 days later,
All right,
This past year?
this past year.
and how large is your property?
About 26.5 acres.
What is the current use of the property?
It's currently agricultural. We just had it planted with grass
All right, is that use intended to continue?
for everywhere except for approximately the center of the lot. We're going to build a house at some point.
All right, and that house is in fact an approved and permitted use in this district, is that correct?
Yes, it is.
Are you familiar with the subject property, the one that is the subject of this zoning application?
Yes, I am.
All right, and what is the current use of that property?
Currently, it has a residence on, and I think a shop, and the rest of it is farmland.
All right, and prior to you buying your property, were you aware that the subject property was zoned to potentially allow a quarry or a mine?
Yes, I was. We had our closing attorneys review our property for any kind of title issues and also the setbacks on the adjoining properties prior to the auction.
Did you in fact review the East Hempfield Township zoning ordinance and notice the restrictions in the zoning ordinance for a quarry and or a mine?
Yes, we did. My wife and I discussed it, and we saw the 500-foot setback.
All right, if there were a 500-foot setback on this property, would you be comfortable with that?
Yes,
Okay, that is what's required by the ordinance, correct?
correct.
Okay. Did you calculate or have you had an opportunity to look at your legal description of the property and know the approximate length of the common boundary that separates your property from this property?
Yeah, it's almost a half-mile long, 2,400 feet roughly.
All right. And are you also somewhat familiar with the zoning ordinance to understand that parking and any buildings are not permitted within 100 feet of the property line?
Yes,
If this variance is reduced, or excuse me, the setback is reduced by 80% or 400 feet, do you believe that would have a detrimental impact on your property?
absolutely. I mean, I did not purchase this property expecting a 100-foot setback when there's a 500 currently. We purchased it knowing what the setback was, and we knew there could be a quarry there at some point. But a 100-foot setback is drastically different than what we purchased at.
I have no further questions, Mr. Elliott.
Before you begin, any board members have questions for Mr. Elliott? I have one, and I'm sorry, I apologize. I think you said it, but I missed it. What is your plan for this property?
If you see where the green is there,
Yep.
basically centered in that property, across from the green, we plan to build a house and a shop. We're currently engaged with the contractor, and we're doing our DEP hydro work and working on our stormwater management, which I would expect would change if any of this was approved. And I already have money sunk in.
Okay, thank you.
Mr. Elliott, I think you just said plan to build a home and a shop. Is that right? What kind of shop are we talking about?
Just a garage for myself.
Garage, okay. And your property is in what zone?
Agricultural.
Okay, and that's the property that we're talking about is zoned mineral extraction, correct?
Correct.
Okay. And when you purchased your property, you were aware of the Pensy quarry across Route 72, correct?
Correct.
All right. Have you ever been at your property since October or before and heard or felt the quarry operations at the Pensy site?
Yes, I have.
So that has an effect on your property already?
I would agree that it does, but it's not within 500 feet of me in any direction.
Okay.
I would think 100 feet would be much worse.
That's all the questions I have for Mr. Elliott.
Jason, you have any questions?
No, I do not.
Township? Gentlemen? Anybody in the audience? Do you have any other witnesses?
We do not, thank you.
All right, at this point, we'll listen to closing arguments before we take administrative notice of everything and close testimony. Go ahead.
First, I'd like to request the admission of our exhibit A1.
Yeah, when I close testimony, I'll take administrative notice of everything.
Okay, thank you. Members of the board, our specific variance request tonight for the 100 feet is a dimensional variance. This is for a use that's permitted by right. And the amount of, I'd like to remind the board that the amount of proof required to establish an unnecessary hardship is less with a dimensional variance as opposed to a use variance. The objector's property is 26.5 acres. He can place his home, I guess, and shop elsewhere on the property perhaps to shift his distance, but he is 100 feet from the Pensy quarry as it would be across the road. So he's already coming to a location that he's 100 feet away from the property line or the quarrying operation across the street. So we request the reduction of the setback to 100 feet from the municipal boundary on the eastern side of the property and 100 feet from other property lines, and the 24-month time extension, if the board would grant us that. Thank you.
Thank you, members of the board. I would mention to the board, this is a variance application. The applicant has the burden of proof. I just listened to counsel, I believe, suggests that perhaps Mr. and Mrs. Elliott should move their house because they have a sizable enough property on which to locate their home. Just to be clear, the burden is not on a protester to make the setback that's in the ordinance work for an applicant who claims that he, she, or it is unable to do so. This is a variance application. I would direct your attention to your application because in your application, you very clearly set forth the 5 requirements for a variance. 2 out of the 5 clearly fail. 3 out of the 5 actually fail. Mr. Karanfa testified that it is the ordinance itself with a 500-foot setback that imposes the unique physical characteristic for this property. This property is 55 plus acres. One needs only to look at the outline of the property and know that there is nothing unique about this property. If there is any uniqueness, it is because the ordinance setback requirements, which the East Hempfield Township supervisor set, cannot be met. And this isn't, while Mr. Williams refers to this as a dimensional variance, I would agree that it is a dimensional variance. It is an 80% reduction of the setback requirements, 80%. Again, it's one thing if this is in the middle of the mineral extraction zone and then argue that, well, all of my properties around me are mineral extraction properties. This property sits on the edge of the ME zoning district. My client's property is immediately adjacent to it, and I think it is incredible to believe that someone can say that there would not be an adverse impact on my client's property with a 400-foot reduction in the setback. If you look at the ordinance provisions, subsection 20 doesn't allow a parking area inside of 100 feet. It doesn't allow a building. And yet the applicant is coming and asking for a reduction in that setback to allow all mining and processing activities, including blasting. The more important situation, and frankly, the applicant didn't answer the question because the answer suggests the result, and that is this applicant will suffer no hardship, none whatsoever, if this variance is denied. This applicant has only an equitable interest in the property, not an ownership interest, an equitable interest sufficient to seek zoning relief, but certainly not sufficient to establish a hardship, because if in fact this variance is denied, which it should be because of the complete failure to satisfy the requirements of the ordinance in the municipality's planning code, this applicant will have the ability, if it chooses to do so, to walk away from this agreement and not purchase the property. That in and of itself negates any hardship on the part of the applicant. For all of those reasons, we would respectfully request that this board deny the variance. Mr. and Mrs. Elliott bought this property. You heard them testify. They did their due diligence. They made a decision based on a 500-foot setback. Now somebody comes in and says, let's forget that setback. Let's move it back to 100 feet. No basis for doing so. That is not fair either to the township and the supervisors who established this ordinance, nor is it fair to an adjoining neighbor. Thank you.
At this point, we will conclude testimony in case number 2499, sorry. Take administrative notice of case number 2496 and enter into the record applicant's exhibit number 1, which is the original application is submitted to the township. Do I have a motion?
Mr. Chairman, in the case 2499, I make a motion that the zoning board take the 45 days administrative time to render a decision.
Do I have a second?
So moved.
Any discussion? A motion to, in case number 2499, to take the allowable 45 days to make a decision. How do you vote, Mr. Callis?
In favor.
Mr. Kyle?
In favor.
And I will also vote in favor. We'll know of our decision probably next month at the July meeting,
Thank you.
which will be the 20th of July. Any problem making that, Jason?
Nope.
Sure. Gentlemen, all good for the 20th?
You good?
Okay. This meeting is adjourned.